episode of the Daily Flip podcast. I'm your host, Alex, and today we're going to be flipping through a story talking about how the Supreme Court has neglected to take up a case about defending the Second Amendment once again. And, of course, we went today with our Daily Delight, a story meant to leave you feeling positive, ready to take on the day. But, hey, that's enough rambling from me. Let's jump into our daily debate. Should the Supreme Court actively protect the Second Amendment? And what I mean by actively is going out and doing what they did in the previous New York case and basically strike down any state rules that infringe upon the Second Amendment. Should we be allowed to have cannons, other types of weapons? Those are the interesting questions, though the taboo ones that you hear all the time. So, with that said, let's actually jump into our first article. This one comes from our first and only article. This one comes from the New York Times. The headline reads, Supreme Court turns down challenge to a ban on semi-automatic rifles. Now, we know that the court has at least stood up before on the grounds of defending the Second Amendment. And the case I mentioned specifically in New York was one of the more recent ones. Now, this is actually a Maryland law that they're trying to address here. With a little bit of background, we get this from the article. Quote, Maryland law was enacted in 2013 in response to the mass shooting at Sandy Hook Elementary School in Connecticut the previous year. It banned many semi-automatic rifles and imposed a 10-round limit on gun magazines. In dissent, Justice Clarence Thomas said the court should have considered the question, which the justices have repeatedly declined to resolve. Quote, I would not wait to decide whether the government can ban the most popular rifle in America, he wrote, end quote. And this is, of course, something that is very front of mind for a lot of individuals, which is if we see the most popular rifle in the United States of America being banned on a state-by-state basis, at what point will it become so normalized, and will those bans be pointed to as examples of how the federal government can operate without having to necessarily defend the Second Amendment so ardently? And at what point are we going to say that it is okay to simply strip these citizens of our entire United States of their right to bear arms simply because precedent has allowed it to continue on without actually addressing these issues? Now, Clarence Thomas is, of course, a big advocate for the Second Amendment, and so is Alito in this case, and Gorsuch. Kavanaugh and Coney Barrett were the ones that appealed, as well as Roberts, from the normal majority and said, actually, no, we don't need to address this right now. They basically, and when it comes to actually uptaking the vote, it's actually not as, it doesn't have to be as unanimous, or not unanimous. It doesn't have to be a majority of the court. It can actually be just a plurality of the court that can decide whether or not they uptake cases. And in this case specifically, I believe it was Kavanaugh that was the deciding vote, or at least the deciding person when it comes to whether or not they would uptake it, and he is getting some flack from it. But let's actually go into some of the more philosophical arguments going on here. Quote, the law's ban on what critics call assault weapons ban did not violate the Second Amendment because rapid-fire long guns are military-style weapons designed for sustainable combat operations that are ill-suited and disproportionate for the need of self-defense, wrote Judge J. Harvey Wilkinson III. That's a name right there, sir. Goodness gracious. Who was appointed by President Reagan. Quote, we decline to wield the Constitution to declare that military-style armaments, which have become primary instruments of mass killing and terrorist attacks in the United States, are beyond the reach of our nation's democratic processes, Judge Wilkinson added, end quote. And this is a quote that I pulled out specifically from here because he makes a point. That's not to say that his point is correct, but he makes a very important point, which would also resonate with many people on the right nowadays, which is the democracy that we have established, the republic that we currently operate within, allows people to enact their will on the political system to some degree. From there, in this specific instance that I'm talking about is every 4 years with a presidential election. Not to forget the congressional and Senate elections, the congressional elections, the House and Senate elections that happen every 2 and 6 years respectively. So to say simply that they cannot voice their opinion, they cannot have a president who appoints judges who actually go in and adjudicate the meaning and the constitutionality of things. All of those processes are nested within the idea that we can actively change and evolve government. And that's not to say that you can simply violate the Constitution, but it does bring up a question, which is at what point are you pushing the bounds of the Constitution within a democratic framework, or at what point are you breaking it? And I would say, honestly, this breaks it, but you can see an argument where this falls within the bounds, that you can defend yourself, you can push back against government tyranny, you can stop people from taking your property and violating your rights in that framework with many other types of weapons without an AR-15. Once again, I don't agree with it, but you can at least understand the argument and where they're coming from. And then the argument from there would be back to them, which is, yes, we do actually have a relatively democratic process because it's called a constitutional amendment, which has to basically be put forward and approved by 2/3 of the states. Eventually, it can be put forward in the House and Senate and then has to be approved by 2/3 of the state legislators. So we do actually have a democratic process for changing something like the Second Amendment. So to pretend as though we have, quote unquote, put it beyond democratic reach is not necessarily fair whatsoever. It is still within reach if you want to restrict what type of guns. They add a clarifying amendment in there. And just because it goes against your predilections as a judge and your reading of the law and honestly your predisposition on guns, because I don't think it okay, let me put it this way. Even if you read the Constitution as a document that doesn't outright say that people have the rights to bear arms, but they only have the right to bear arms in militias or certain types of arms, not certain types of arms, because it doesn't specifically say certain types of arms. But even if you read it as something that is a more limited view and one that is very often used by people on the left, that doesn't necessarily mean that it falls within bounds to say that that gun is outright banned by those same constitutional references that you were just making in order to say, well, we can actually restrict it a little bit because you're not in a militia. So in order to hyper-target a certain gun, you have to come in with preconceived notions of what is acceptable and not acceptable. That's not to hate on this judge. Of course, every person comes in with those sort of convictions, and everybody has their predispositions, especially people who have been working in these fields for a long time and heard many cases and heard many arguments for and against them. But that doesn't necessarily mean that your opinion, sir, the honorable judge. It doesn't mean that your opinion is the only one that matters, and it's not to say that you can simply lambast the culture for saying that we shouldn't touch these things as a culture of untouchability, of infallibility for the Second Amendment, just because you don't necessarily agree with it. Now, I understand his frustration for sure, and I think the next quote possibly highlights some of the tension going on here. Quote, rather than considering the amendment's plain text, the majority sidesteps it altogether and conducts a threshold inquiry divorced from the right's historic scope, wrote Judge Nullis R. Richardson, who was appointed by President Trump. Quote, to make it worse, it means misconstrues the nature of the banned weapons to demean their lawful functions and exaggerate their unlawful uses, he added. Finally, to top it all off, the majority cherry-picks various regulations from the historical record and pigeonholes them into its preferred yet implausible reading of our nation's historical tradition of firearm regulation. And people are lambasting the courts, the previous appellate court, but also the Supreme Court for not actually taking this argument up. And this is something we cannot avoid. As we move forward, are we going to have a Supreme Court, a judicial system that actively pushes back against any sort of infringement in their plain reading of the text? Or are they going to be people that simply let these sort of things fly because it is simpler that way? It's a great question. They don't necessarily want to get the flag for it. They don't want to address it. I want to see how this one plays out, because at the end of the day, the Second Amendment is our most value. The First Amendment is the most important. The Second Amendment is the most valuable. And what I mean by that is value is determined by something that value is determined normally by the amount of effort that has to go into things, and therefore the rarity of it. Those things can be linked because it's rarer, which means harder to get out, which means there's more labor that goes into it. And very seldom, very rarely, are you going to have to defend yourself against your government. But when you do, you want the Second Amendment there to be backing you up, saying you actually have the right to get these sort of things, and you have the right to persist against a tyrannical government. So, with that being said, and there's one particular person that if they hear that, they're going to say, oh, you just said it's the most important amendment. That's why I clarified with the First Amendment. Had many conversations with a few friends about that one. But the point being is we'll see how this next term goes, because Kavanaugh specifically says that he wants to address it here in the future. But with that, let's get into our Daily Delight. This one comes from Dog Time, video of, quote, dog and cat cannot decide between playing and fighting. And honestly, the series of videos that you get from this one are absolutely adorable. There's no doubt in my mind that their human parents, are watching every second that they go back and forth, and that they battle with absolute joy. And that's exactly why they're sharing it on to you. Hopefully you can walk away with a little bit of a smile after watching it. And if you want to check out the podcast on Spotify, Pocket Cast, Podvine, all those links will be in the description below that like and subscribe button. Also down there you can find the podcast link to actually our Twitter handle, which is at Your Daily Flip, where we post links to these episodes on Monday, Wednesday, Friday, and also to 6 and 6, which is 6 stories from around the world in 6 minutes or less. It's international news, and that comes out on Tuesday and Thursday. So, with all that said, there's only one more thing to say. Stay safe, don't die,